And I wish this thing is so hard.
Yeah. Microphone's on, I think.
It is.
Hello, good morning.
Good morning.
Everyone.
Good morning.
The 357 District Court will call its court into session for today's docket civil, starting at 8 o'clock morning, Wednesday, April 27, 2022, starting with civil hearing 2022 DCL 4070, Security Service Federal versus Paul Jonathan McLean.
Good morning, Your Honor. Mara Schechter for Security Service Federal Credit Union.
Paul John McLean. Anybody here for Paul John McLean? All right, proceed, man.
Good morning, Your Honor. On June 26th, somebody's got their audio on. It's giving refurb. Sorry. Your Honor, on June 26, 2019, Mr. McLean signed a contract for a 2017 Cadillac ATS. You'll see in Exhibit A. On January 26, 2022, the plaintiff filed its original petition and application for writ of sequestration. On February 4th, 2022, the defendant was served with both. He would not surrender the vehicle, and we obtained the vehicle. We held it for 10 days. The sheriff did. That expired on February 15th, 2022. On February 28th, 2022, the defendant's answer was due. As far as we know, as of yesterday, we have not received any response from him. And as far as we know, as of yesterday, he hadn't filed anything with the court.
All right, proceed.
On March 29th, 2022, Security Service Federal Credit Union, the plaintiff filed a motion for default judgment. Attached to that motion was Exhibit A, the certificate of last known address. Exhibit B, the business records affidavit of Patrick Ryan. Exhibit C, the attorney's fee affidavit. And Exhibit D, the Soldiers and Sailors Relief Act affidavit. A notice of this hearing was mailed to the defendant on April 5th. As you know, the writ of sequestration allows. Thank you, Your Honor. It's been a long week for me.
I understand.
Allows SSFCU to repossess the vehicle ex parte subject to the underlying lawsuit. We're here on that underlying lawsuit. So we would ask for judgment for Security Service Federal Credit Union, and so that we could maintain possession of the vehicle and excuse me. We'd like our bond released. We'd like judgment for the entire amount against Paul Jonathan McLean so that we can get the remaining balance due under the contract.
What is that amount?
You know, Your Honor, I do not know. It depends on how much we sell that vehicle for. So once we sell that vehicle, we'll know how much.
I'm assuming you're suing on contract here. I mean, he indebted himself to pay for X amount for the car based on credit and installments. And so what was the default amount at the time that you triggered your actions?
$19,711.18 plus interest,
Okay.
pre and post judgment interest, the contract rate of 4.4%, Your Honor.
All right. All right. The court will take judicial notice of all documents and file this case. The court will admit exhibits A, B, and C, and D in support of the default judgment, having called out the name of Jonathan McLean. No answer having been had, the court hereby grants a default judgment prayed for in the amount prayed for and allow the relief the plaintiff may be entitled to. Anything further?
No, Your Honor, that'll be all. Thank you.
Thank you. Have a good day.
Thank you.
All right. 2017 DCR 5673 La Concha Condominium in the city of South Padre Island. All right, this is a plea to the jurisdiction based on that I have no jurisdiction because is that your argument, the city of South Padre Island, Mr. Drinker, I don't have the jurisdiction because the property that is being complained of or the subject of the taking is located within the city of of South Padre Island. And as such, that city of South Padre is not subject to the regulatory requirements that Mr. Boyarski is complaining about. Is that accurate?
That's part of it, Your Honor. That's exactly right as to one of the claims.
What's the other part? What's the other part, Mr. Drinker?
The other part is they have a takings claim in addition to that, Your Honor.
Right?
And there's no subject matter jurisdiction because they haven't pled any facts that can fit within a takings claim.
All right, Mr. Boyarsky, what is your response?
For the takings claim, Your Honor, you have to take our pleadings on their face, and the pleadings are correct. They had filed special exceptions. And as you know, I think this is the fourth time we've heard this motion. And, we've gone through this again and again and again. And I think this is just another attempt by the city to outspend and run off the plaintiffs and then threaten us with the Court of Appeals again. This, as you know, this has already been to the Court of Appeals twice. And they filed this motion actually back in 2017. They filed it again in 2019. And to show you how bad it is, I basically took the last response I did and reworked it and filed it again for you. How many times are we going to do this? They're wrong on the extraterritorial. They have the beach is owned by the state, not by them, and they have extraterritorial claims. It's pled that way. And I think if you read our response, it goes line by line because you have three different sets of facts to deal with. You have a takings clause that's in the petition that's under 2007 of the government code. You got to read all that and judge, this is complicated and time consuming, and this junk belongs at the Court of Appeals with a 75-page brief. That's how difficult it is. Additionally, you have, in addition to the takings under the government code, you have a constitutional claim that Mr. Drinkard says that we haven't pled enough, and we certainly have. And then, of course, the answer to that, and on a plea to the jurisdiction, is you have to give the plaintiff additional time to make his. If in fact you find the pleadings inadequate, you got to give the plaintiff additional time so that they can make their pleadings adequate. We have asked for additional time if that's the case, because we needed and filed, I think the fourth time, we've asked for additional deposition time. For example, I need to take the deposition of the city's mayor. Well, so the court knows the city's mayor is also the guy who built the boardwalk in question. So, this thing is all tied up in one big knot. I've got to be able to get some more deposition time to see.
Let me ask you this, Mr. Boyarsky. Aside from that, what appears to be a critical witness, the mayor who built the actual thing, what else do you need to properly respond and amend your pleadings to respond to this?
I think my pleadings are adequate, Judge.
Okay.
If you look at it's the seventh pleading. It's the seventh amended petition, and I think it's, hold on, I'll tell you in a second. It's like about, I think we are up to, it's a 4-page petition that has all three of the actions: the constitutional action, which is specifically pled under the sections 17 and 19 of the Texas Constitution. You've got the takings 2007 government code, which is pled, and also pled as inverse condemnation. I don't know what else they need.
Then let me reframe my question. Let me amend my question to ask you, what deposition do you need so that you won't come back to me and tell me, well, I still haven't taken it. What do you need besides the one you already pointed out?
Okay, we could use the mayor who built it.
Well, that's what we're talking about. We already talked about that.
Right. There's an engineer who did the study on the program. And if you remember this case, Judge, this is the one that gave no notice to the property owners, none. So we have the guy who set up the program and the engineering who did the engineering study, because the builder, the mayor, has told me informally that he was just following the plans that the city gave us. So I need that guy too. Those are the two that
Your
are.
Honor, if I could respond.
Is it possible, Mr. Drinker, that you make those two people available ASAP so that we can get this thing over with one way or the other?
Well, Your Honor, and if I could just respond, I don't know why he would need the mayor's deposition for this. The basis of this part of it is simply Where is this structure located? Is it in the city limits? That's beyond dispute. Why would you need to depose the person who built it to decide whether it's in the city limits? And number two, there's no takings claim. Supreme Court has said there's no takings claim for something built on a neighboring property that blocks a view. Again, the mayor's deposition would be irrelevant to that. What he wants to depose the mayor about, Mr. Boyaki's already taken 5 or 6 depositions in this case. I haven't finished one. He's taken 5 or 6. It's just another attempt to stall on an issue that he doesn't need discovery to respond to. He's satisfied with his pleading as it is. He said that numerous times. So, you know, I want a ruling on this. The mayor is just another reason to stall. One more thing that Mr. Boyaki was clearly wrong about, Judge. This particular motion has never been heard by you. I filed it once before the pandemic. It never got heard. We never had a hearing. We're here for the first time. What went up at the Court of Appeals, and he actually said this has been at the Court of Appeals twice. That's just wrong. It's been there once. What went up to the Court of Appeals was a standing issue, solely standing. And I've got the opinion that Mr. Boyaki attached to his response that says that. It says the trial court denied a plea on the basis of standing. And that's what we're hearing. I lost that. So that's why we're back here. That's the only thing that you've ever ruled on that's been heard. That's the only thing that went to the Court of Appeals. This is a substantive motion that they haven't pled adequately. And Your Honor, to answer your original question, I don't know who the engineer is that built this. I don't have any control over the engineer, but the mayor, I mean, even though I think it's totally unnecessary, I mean, I can make the mayor's.
Who would have contracted an engineer to go and do an engineering map of the proposed, who would have dealt with that? I mean, I'm sure that Joe Blow can't just come to the city of South Padron and start building something without meeting any requirements or what. Who petitioned to make that entryway in that beach access that we're talking about? Who petitioned to do that?
From the city?
If it wasn't, the city had nothing to do with it. Who did the city supervise, regulate in order to have that done?
Oh, Your Honor, the city was involved, and Mr. Boyaki's already deposed all 3 people from the city. All 3 people, the shoreline director, he's already taken their deposition.
Did the city employ an engineer at that time to do this?
City employees, yes, were involved, and he's deposed them.
The engineer.
Oh, no, the engineer was, I believe, and he may have deposed the engineer, but it was not a city employee. That was a contracted engineer. The mayor was the contractor at the time. He wasn't the mayor. He was the contractor who built the walkover at the time. So, and my contention.
The construction contract of this access was entered into by formal action by the city of South Padre Island?
Correct.
Yes,
Correct.
Okay. And you approved all the drawings, all the specifications that were going to go into this, right?
The city and the state did, correct.
The city and the state. Okay. I'll tell you what I'm gonna do. I'm gonna go. I read it briefly enough to garner what this was about, your petition, but I need to go look at this petition and take a look at this. I will have a ruling to you later on today or tomorrow.
Thank you, Your Honor.
All right. Thank you both.
Thank you.
Ms.
It would be
Ana,
excused, Your Honor.
this one, yes. Yes, Mr. Brinker, thank you.
Thank you.
On this one, give me the last petition, amended petition, as well as the Court of Appeals opinion, if you have it. Thank you. All right, 2022 DCL 1860, Ernesto Garcia, Freira Lopez, Juliana Sosa.
Good morning, Your Honor. Juliana Sosa here on behalf of petitioner, Mr. Ernesto Garcia.
Where is Mr. Garcia?
He should be present on Zoom.
Mr. Garcia, unmute yourself. Come on, it's your case.
Yes, sir. I'm right here.
Okay,
I'm right here. Yes, sir.
I hope you're not driving, right?
No, sir. I'm parked.
All right, good man. All right, let's proceed, Ms. Sosa.
Your Honor, Nemesio Lopez for the record, Your Honor. I represent
Oh.
Frida Lopez.
Oh, I didn't know there was another, my docket didn't show up, opposing counsel. I'm sorry, Mr.
Right.
Lopez. What's going on? All right, well, are we ready to go on this?
Yes, we've conferred, I conferred with Mr. Lopez yesterday. He asked for a reset. We're not opposed. We're just asking that this court extend our temporary restraining order. And in addition to that, I believe Mr. Lopez had some objections to you hearing this or presiding over this case. Mr. Garcia, my client, was previously, you were his attorney previously, is my understanding. And that's,
I don't recall him, but well,
Yeah.
let me listen to Mr. Lopez's objection.
yes.
Mr. Lopez,
Yes, Your Honor.
I don't believe I should, I should do this. I should be listening to this case because,
Your Honor, I was informed, Your Honor, and maybe we can ask Mr. Ernie Garcia himself. I was informed that you represented Mr. Garcia in a custody case when he got divorced. And
that
so
might be true. You know, that's been such a long time since I practiced law. It's already going on 9 years. So,
yes, Your Honor.
and I'm getting older. And as you know, Mr. Lopez, when you get older, stuff happens.
That's correct, Your Honor. So
Including
actually,
your
I'm
memory.
here.
So I will stand here telling you I have no idea whether I did or not. I don't recall the case specifically, but I'll let Mr. Garcia enlighten me. Did I represent you, Mr. Garcia?
Yes, you did, sir. It was a custody case, and Judge forgot her name. She's a county judge here in Harlingen. She recommended me to you, and I believe it was kind of a pro bono situation. It was for my two sons, and
Okay.
it was one of your last
Hurrahs in the private world.
case. Yeah, it was one of the last cases you took right before you got elected as a judge.
All right, well then, if your wife doesn't feel comfortable with me, I mean, you're currently a respondent or defendant in this case does not feel comfortable with listening to this matter because of that background, I'm gonna have no choice but to withdraw and send this case to another judge. That's where she may feel more comfortable if everything's being objective on the up and fair and impartial, okay? So,
Okay.
so that by reason of that, it's going to be delayed. Can you transfer it to Judge Ureste, and we're going to transfer it to my presiding judge, Judge Ureste, and he'll make a decision as to what judge he will assign it to. Okay? And you will be
Okay.
hearing from that judge. Thank you. Thank you both for being here.
Thank you. In the interim, we would just ask that the
Well,
restraining.
everything stays in place. There's been no hearing dissolving and modifying, and I can't proceed forward even if there was. So you need to deal with it with a new judge. But I would think that at this point, everything should stay status quo until you get a new judge to hear your complaints. Okay?
Yes, Your Honor.
Thank you.
Thank you.
Have a good day.
You too.
You too. Thank you.
All right. Transfer that one out. All right. This stuff is at 9 o'clock. The criminal cases? Okay, that's right. All right. Did Mr. Hinojosa arrive?
Yes, Your Honor, he's here in the courtroom.
Oh, okay, well, tell him that, His Royal Highness is ready for him. So that's like, what are you doing with this case on 2020 DCR 726? You ready to rock?
Judge, it's gonna have to be a trial. I don't know if
Alrighty.
the state's
Great.
ready or not.
Well, it's too bad. They're gonna have to be ready.
Okay. It's a child sex case, so I don't know if they've got other people in custody or something in other courts.
They knew it was coming. It's been on the docket for almost going on 2 years now.
Judge, Miss Bailey just advised me that she's currently in trial and her trial will dip into next week.
Okay, well, one of you choose a jury for her, and when she finishes, you can come into mine and start trying this case. There a problem with that?
We know nothing about. She
What?
picks her trial team.
Well, Mr. Aviola, I can't deal with you if you're not the prosecutor in this case. So at the very minimum, I would ask that Ms. Bailey get on the screen and talk to me about this case.
She's currently in trial right now, Judge. She did say that she is available June 27th.
2021 DCR 752, Sarah Destiny Bennett. Mr. Gracia. 2021 DCR 51, Natalie Lindsay Charles. Mr. Rivera, call out Miss Bennett and call out Miss Charles.
Good morning, Your Honor.
Miss Natalie, okay, she's here.
Yes, sir.
All right, what, call out Miss Bennett, Sarah Bennett.
Yes, Your Honor.
2021 DCR 1546, Mary Michelle Escobedo. Mr. Monares.
Good morning, Your Honor.
Good morning, sir.
Good morning.
Morning, ma'am.
I do believe she signed in as iPhone, Your Honor. Is that correct, Mary?
Yes, yes, that is correct. I'm sorry.
What are we doing with this one, Mr. Monares?
Yes, Your Honor. We have an agreement with the state. It just requires that I tie up the 2 misdemeanor cases. I need to speak with Edward Sandoval to make sure that that happens, but we do have this case resolved.
So what are you asking me for?
If we could get a 30-day reset, just so I could get the 2 misdemeanors resolved before the next time we come to court.
Give me 30 days, Ms. Sarah. Yes. May 25th, Mr. Monares.
We'll be back, Your Honor. I
Thank you.
appreciate you.
Take
You
care.
may be
Thank
excused.
you.
Yes, sir.
Your Honor, Saraí Bennett was called 3 times and there was no answer.
What says the state?
They asked the KBS be issued bond before to no bond and judgment NICE be issued in favor of the state.
Okay. The first Gracia case. Sarah Destiny Bennett. Where is Mr. Gracia?
He's logging in right now, Judge.
What do we have June 27th? June 27th. Okay. Okay. All right, Mr. Garza. Mr. Garza and Mr. Arriola. Where did Mr. Arriola just come in, pipe in and leave? Or what?
No, he's there.
Where are you? Oh,
Yes, Judge.
advise Miss Bailey that I've given her trial date, June 27th. I'll see her then, Mr. Garza. I'll see you on June 27th.
Thank you,
Thank you,
Judge.
Judge.
You're not gonna go off and kill anything on June 27th, are you? It's too hot. Mr.
No, but I will be on my way back from my 15th year anniversary vacation with the wife, so I'll be well rested and very relaxed. Okay, Judge, thank you.
Well, announcement 24th. Announcement.
Oh, I might miss that, but
Well, you can just call it in, Mr. Garza, but I'm sure that you will be ready. I'll
Yes,
take
sir.
your announcement. You're ready, and everybody be ready, except Miss Bailey. Kids, I'm assuming she'll be ready because she asked for that trial date. I've given it to her.
Okay, thank you, Judge.
Thank you. Take care. So put the Jose None Garcia. Mr. Gracia,
Yes, Your Honor. Good morning.
Mr. Gracia.
Yes,
Bennett did not appear, so I've KP'd her.
very well, sir.
Miss Charles is here. What are you doing with Miss Charles?
Ms. Charles has been conveyed an offer that I believe that she's going to accept, Judge, the state's.
You want to go to a breakout room and talk to her about it, or do it this morning, or you're not ready to do it this morning?
No, Judge, because we still need the plea paper signed and all the rest of it. So I've explained the offer to her, but I want to make sure that I get all the paperwork and go through all of the proper
How long
admonishments.
do you need?
I think with the short 30 days, I know I can get it all done.
That's a long time, Mr. Gracia, for plea papers and all that.
All right,
I'll reset it for next week, next Wednesday.
Judge, I'm not going to even be in town. I've got a CLE that I'm going to be heading to. If I could get at least 2 weeks, I mean, I know I can get it signed up. It's not going to be a problem.
May the 11th.
May the 11th. Okay.
All right.
Very well, Judge.
All right. Thank you, sir.
Thank you. I believe that's all the matters we have before the court. May I be excused?
Yes, sir. Have a good
Thank
day.
you. You too.
Thank you, sir.
Thank you.
Bye-bye.
All right. Where's Mr. Hinojosa?
I'm right here, Your Honor.
He's right there on the screen.
Well, I thought you all wanted to meet with me.
We do, Your Honor.
Well, then I'm ready for you.
Oh, I'm sorry, Judge. We're heading back there.
Hello, hello, my flies.
Rolando, did he log off?
He did, okay.
I'm gonna end the Zoom because this is.
I told him,
Let's
I told
end
him
it.
to come after the Zoom.
But you're gonna wipe out Mr. Crowley's.
You need an interpreter?
Interpret us.
Do they need an interpreter?
No, he doesn't need an interpreter.
Mr. Lee,
Okay.
so you'll know that you were at work. Could you interpret good morning for me?
Buenos días.
Dale. Good job. Excellent.
Thank you, Your Honor. It's always a pleasure.
See you all later.